Okay, Judge Stevens, it looks like we have attorneys for all parties present, as well as the court reporter, and we are ready to begin when you're ready.
Okay, give me just a moment. Okay, at this point, the court will call the case of the University of Michigan Professional Nurse Council versus Regents of the University of Michigan, case 20210-203. This is the date and time for a hearing on the request on the part of University of Michigan Professional Nurses Council for a temporary restraining order and preliminary injunction in aid of an unfair labor practice claim filed with Merck. If you would please bring counsel in and have them state their appearances.
Good morning, Your Honor. Robert Fetter on behalf of the plaintiffs or plaintiff.
Good morning, Your Honor. David Masson representing the University of Michigan.
Good morning, Your Honor. Andrew Nickelhoff representing Michigan Nurses Association. Along with me is Andrew Smith, General Counsel.
And Your Honor, Judy Champa is co-counsel in this case and is present as well, but I will be presenting.
Okay. We have a court reporter, Ms. Williams. You will probably never hear from her, but if you do, it will be because she couldn't hear us. And she will unmute herself and either present herself physically or otherwise so that we will know that there was a problem. Previously in this case, a motion to intervene was filed. That motion to intervene was granted without opposition by all of the parties. The court is aware that in Washtenaw County Circuit Court, there is a corollary proceeding, as of course there is in the Michigan Employment Relations Commission. On behalf of the movement, if you would proceed to share with the court why injunctive relief is appropriate, and most importantly for me, that which draws my attention is your prayer that in this injunction, I should, amongst other things, preclude the University of Michigan from recognizing the other labor organization. So please proceed.
Yes, thank you, Your Honor. This is being presented on plaintiff's motion for a preliminary injunction. And we do not seek as a matter of relief to displace the M&A. That has been a red herring that has been presented. In the relief sought.
I want to make sure. I'm looking at your papers.
Mm-hmm.
And when I look at your papers on page 2, it says you are asking me to do 4 things. To order that the defendant do not recognize the M&A appointed executive committee as executive committee members of UMPNC.
Mm-hmm.
Order that the defendant not threaten or actually discipline or discharge any elected executive committee member of UMPNC for performing union duties. Order defendant to show cause. Well, we already got past that part. So let's look at those 3. Right. And if I understand what I'm hearing, you are telling me, oh, pardon me, there was one before that. I should have read that. Order the defendant recognize the elected executive committee of UMPNC as UMPNC representatives in their respective positions for which they were elected. Is the nuance that I should have appreciated that you are not asking the university to recognize labor organization A as opposed to labor organization B, but that you want them to recognize the persons who work for your client in their capacity as executive committee members and with the duties of executive committee members within that labor organization?
That's right, Your Honor. We're not asking to displace the M&A. The M&A has their representatives and they can maintain. It is who is the representatives of the local union, which is my client.
Well, okay, so here's what I've got to work out in my brain, and I'm sure your labor folks, it's been a long time for me since I did that work. So if the university recognizes your executive committee persons as executive committee persons of the labor organization and is to allow them to perform their duties, amongst their duties, I would think would be if a grievance was filed on behalf of a member or if discipline was meted out against a non-executive committee member, and that individual wished to appeal the discipline, they would be appealing it through whatever the contractual process is, which at some point in time requires an executive committee member to facilitate, whether it's step 1, step 2, step 3, make sure that there is a representative at the initial conference, make sure that that representative apprises the individual of their rights. At some point, as they get to a certain level, presents it to an executive committee to decide if they're going to take it beyond whatever level is automatic within your collective bargaining agreement. Do I misunderstand that process and those duties of an executive committee member?
That's right. There's one of the executive committee members is called a dispute chair. That is the person that handles the grievances. So if there was a grievance filed, the first 2 steps are handled by the local exclusively. Mm-hmm. And then at the 3rd step, it's handled jointly with the local and the M&A. So it would be based on who is the representative that the employer deals with for those grievances at that example. Now, there are other situations of what are commonly called stewards that they have particular areas that they handle where sure. It is the representative that represents the particular member in that area.
Which does mean that as relates to ongoing labor management relations, there are roles for at least the dispute person amongst the executive committee.
Yes.
So I'm employee Jones. If the university is recognizing the other organization, then it is their executive committee member who would take on that dispute role. If they're recognizing your client, it is your executive committee member designated for disputes that will be taking on that role.
A little bit different. The
Okay.
M&A has appointed individuals that serve in those roles. And so it wouldn't be an M&A employee, for example, that would be playing that role as a dispute chair. It is somebody that the M&A has appointed to that role from
And
the
counsel,
market.
I was very careful. I did not use the word appointed. I did not use the word elected. Okay.
Right.
I said,
Right.
doesn't matter how they got there. There would
Yeah.
be a human from one entity or a human for the other entity taking on the role of managing disputes in accordance with the collective bargaining agreement.
Yes, there would be.
So potentially there are two people whom the university would be dealing with on the same grievance and the same employee, right?
Yes, it's who the employer deals with for
Okay.
these issues.
And who they deal with has to do with who they recognize, doesn't it?
No, well, I don't think that there's a dispute that they recognize UMPNC. The issue is whether they recognize the disaffiliation and whether M&A has any right to make those appointments that they did and remove
Regardless
the
of how
leaders that
we,
they did.
and I appreciate the very fine language regarding the disaffiliation. But for the practical purposes of employee Jones,
Mm-hmm.
it's who's going to take care of them.
That's
okay?
right. That's right.
And that goes to the heart of the issue before Merck. So while I understood with whether I agree to do it or not, I clearly understood the request that the persons who were elected to the executive committee not be threatened with their employment for doing whatever they would do as executive committee members, and that they be able to continue their roles in the collective bargaining organization from which they were elected.
That's right.
That one has nothing to do with employee Jones directly, so long as we're letting Merck do what Merck does. So I was trying to understand how the relief in the 2A and B level of relief were not substantially requiring a decision on who's in charge. Let's put it that way.
Right. So to answer that question, the current collective bargaining agreement recognizes UMPNC as the local union and recognizes M&A as their parent. It
Yes.
recognizes both of those organizations. What M&A has done is illegally taken over UMPNC after it decided to separate from its parent organization. And then it has put in an entire new group of leaders in an organization that it has no control over.
And that is your dispute in Washington County Circuit Court, and I am sure it will be resolved there. But for my purposes, objectively, it is your job to use advocate's language. Okay. As I understand the objective circumstances, there is a collective bargaining agreement between the University of Michigan and the labor organization known as MNPC. That collective bargaining agreement continues to be in effect. Am I right there?
That's right.
That an action was taken that is described as disaffiliation from the parent. Is that correct?
That's correct.
Okay. Was valid, but there was an action taken. That subsequent to that action taken to accomplish disaffiliation, the parent entity from which the disaffiliation was sought engaged in activity which it would describe as preserving its rights, you would describe as disrupting the rights of the members of MNPC, and appointed persons to act. I'm not going to call them trustees or receivers, but to act as an entity managing the local over some period of time. Did I understand those objective acts? Now, whether they're legal or illegal, I don't know. But those were the steps.
Yes.
Okay. Well, I've asked you too many questions and haven't let you give your argument, please.
No, I enjoy the questions, Your Honor. And I appreciate the time you've taken to attempt to understand these somewhat unique concepts.
And I appreciate the word attempt.
And I think you have it pretty well. This isn't my first time appearing before you, and I know that you always engage in take your due diligence to look into those issues, and I do appreciate it. But I want to summarize a few issues, and I know that you always take the time to read everything that attorneys submit to you, so I don't want to just merely rehash the brief, but there are a few issues that I want to take up. Now, first of all, the issue here in this case is solely whether injunctive relief is necessary to preserve the status quo ante for the university's actions of recognizing the M&A appointed individuals of UMPNC. We do not seek this court or any action in this court to determine who is the sole bargaining unit or bargaining agent between the two entities. That'll be resolved at Merck. This only challenges whether the status quo of the elected representatives, the representatives of the employee's choice while this action is pending before Merck, should continue in their roles. And, as you said before, not to threaten or discipline those UMPNC elected executive committee members for performing their union duties. A couple of issues that I want to raise. One is, I think, kind of an ancillary issue, but addressed in the supplemental brief of the employer. There's no doubt that at this point, if the employer wanted an election, they could file an RM petition. In fact, I provided the court a case where in an almost identical situation regarding an independent union and its former parent union, had a similar dispute at Hurley Medical Center, and it was resolved through the employer filing an RM. In response to that, the employer has submitted a case which is totally off base. The case they submit has to do with whether the members continue to want to be represented by a union at all. That is not the case here. The dispute is whether the members want to be represented by one union represented in the contract, recognized in the contract, or the other union recognized in the contract. That is it. They have every right to file an RM petition, and they refuse to do so. They also confuse two related issues, or similar words anyway. I think they're very different issues, and that is disaffiliation and decertification. They cite many decertification cases throughout their briefs. A decertification case is when there's a rival union, an outside union, that wants to displace an incumbent union who currently represents the bargaining unit. This is not that situation. This is a disaffiliation case where there's a parent and a subordinate union, and the subordinate union chooses to leave the relationship with the parent. Both have a representational capacity with the bargaining unit. That is the situation here. And the employer has had some shifting rationales. It initially, immediately after the disaffiliation, in its letter on January 3rd of 2021, indicated that it will continue to abide by the contract and recognize both entities, because the contract recognizes both entities. It is between the employer, M&A, and UMPNC. It has now changed its tune and said, now we're only going to recognize the M&A. We're not going to recognize UMPNC, or we're going to recognize M&A has total control over UMPNC. Now, here's why that's wrong. The Merck precedent that is clear, concise, has no dispute, of which the defendants refuse to address, is when an employer must recognize an affiliation or disaffiliation of a local union. This law is clear. It goes back decades. There's case after case, and there's only two issues. And if those two issues are met, the employer must recognize the employee-free choice of what the employees have voted for. One is whether the vote occurred with the appropriate procedural safeguards, notice, opportunity to discuss, and a secret ballot. Undisputedly, there was notice to all members in this case. There was an opportunity to discuss the issue, debate the issue, both at the meetings and between the within the notice period, from the time the notice went out to the time that the election was held. And the vote happened by secret ballot. It happened virtually through the anonymous poll feature of Zoom, because we're in a pandemic. So the second issue is whether there's continuity. Is the organization materially changed, or is it a different entity after the disaffiliation? And in those cases, what you look at is, are the leaders keeping their spots? Is there any major change to the organization of the local union? Here, there are no changes to the local union. The leaders all kept their spots. Everybody would have stayed in the same place. They would have had the same office. They would have had the same everything. The only difference is they're no longer affiliated with M&A. So those are the only two issues that Merck will look at: procedural safeguards and continuity. If those two things are established, which they are in this case, and they will be at Merck, then the employer must recognize the disaffiliation. Now, if they must recognize the disaffiliation, what does that mean? Well, all we're asking this court to mean is not to say that who the exclusive bargaining representative is, because that'll be handled at Merck. All we're saying is, as part of the employer's obligation to recognize the disaffiliation, they have to recognize that the M&A doesn't have control over the entity. That's it. And if the M&A doesn't have control over the entity because they've recognized the disaffiliation, then they have to put the elected leaders of UMPNC, who are supported by employee free choice because they were elected, keep them in their spot and recognize them as the representatives. Otherwise, they are interfering with the internal administration of the union. They are violating the members' rights to free choice. And we're left at a spot now where every day through the pandemic, these nurses are not being represented by individuals that they elected, that they chose. They've gone through a process. The elections weren't that long ago. They were in October of 2020. And M&A prior to the disaffiliation sought the removal of some of these officers because they didn't think that they were sufficiently loyal. But these are the members' choice. These are the people that they want. When there are issues regarding the pandemic, regarding patient safety and safety of the nurses, they should have the representatives of their choice. So what we're asking for this court to do is to stop the irreparable harm that's happening right now of the nurses not having the representatives of their own choice and self-determination, and amongst the other elements of irreparable harm that we've mentioned in our brief, so that while this is pending, the nurses can enjoy their statutory right to the representatives of their choice. Thank you, Your Honor.
In response by the University of Michigan, please.
Yes, Your Honor. The issue that you raised at the very beginning of this hearing is really the nub of the issue for the university. So the university was put in a position on January 22nd when the M&A placed UMPNC into trusteeship and appointed interim officers. The university was put in a position where they had to recognize, they had to choose who ultimately they were going to recognize. Up to that point, the university continued to follow its collective bargaining agreement and the certification of Merck. So Merck certified the M&A as the exclusive bargaining representative. For the last 40 years, the parties have a collective bargaining agreement that recognizes the M&A and its UMPNC as the exclusive representative. Counsel for UMPNC admits that the status quo was the recognition of M&A and UMPNC as a local bargaining unit. The university has never recognized UMPNC as a sole standalone bargaining unit. Up to January 22nd, the university continued to recognize the current officers of UMPNC until M&A placed the union into trusteeship. As to the union's argument that somehow the disaffiliation results in the transfer of the Merck representation from M&A to the UMPNC, the cases cited by the union are all distinguishable. None of them deal
Counsel,
with, yes.
Just to help us in the record, since we have two unions,
Yes,
we probably need to call them by their initials.
I am so used to just arguing against a union that I'm sorry. So the cases cited by UMPNC in their brief are distinguishable. They're distinguishable because none of those cases apply to a situation where the commission, where Merck had actually certified a particular bargaining representative. The only case that's been presented that's directly on point is the NLRB case of Yates Industries. In Yates Industries, that was a case where, in fact, the national union was the certified bargaining representative. The local union attempted to disaffiliate. The employer recognized the disaffiliation and followed through on the request of the local union to appoint the disaffiliated officers as a bargaining representative. And the NLRB found that the employer had committed an unfair labor practice. That is what the UMPNC was asking the university to do in this case. And that is what it is asking this court to order the university to do. The UMPNC is asking this court to order the university to recognize representatives of a standalone UMPNC. The standalone UMPNC has not been certified by the Michigan Employment Relations Commission. The university does not have evidence that they have majority support. The university does not have evidence that the M&A does not have majority support.
Counsel, your colleague suggested that when placed in this position, that you have an option to file your own action with Merck. What's your response to that?
Right. The case that I cited yesterday in the supplemental pleading indicated that to file such a petition, the employer has to have a good faith belief that there is a question regarding representation and that, in fact, there may be a lack of majority support. At this point, the university does not have that good faith belief. The only evidence that we've been supplied with is the fact that 1,075 nurses voted in support of disaffiliation, approximately 17% of the bargaining unit. That is certainly not the evidence that would indicate to the university that there is a lack of majority support. The university would be happy to file the RM petition.
I want to make sure I understand what was given to you. My understanding is that you were given papers that would indicate that a meeting was held at a date and time and place virtually. Is that correct?
Yes.
And that of the persons who attended that meeting, the 1,000, et cetera, that you described, voted in favor of disaffiliation. Is that correct?
Correct.
Okay. And that one of the bases on which you say there is no good faith belief is because the number of persons who appeared at that meeting was a minority of the members of the collective bargaining agreement, of the collective bargaining unit. Yes.
Judge, I would say that the basis is that the university does not have evidence that the M&A does not enjoy majority support.
Okay, I know what you said, but you gotta have to answer my question. If you've got, and you may have some other reasons to doubt things, but if you've got papers that say meeting was held on day X, notice was given on day X plus 20. At that meeting, a vote was taken. X number of persons were at that meeting. A majority of the persons present at that meeting voted to disaffiliate. For me, logically, your question and your absence of good faith would either be occasioned by information that I didn't really see in your papers regarding the notice or the manner in which the meeting was held, or, and that's what I did think I saw, the fact that the number of persons who actually arrived and registered as being at that meeting was a substantial minority of the members who are represented by the collective bargaining unit.
Well, that's correct. I mean, what the university needs is evidence that a majority support the UMPNC and don't support the M&A.
Okay, and so you're
frozen.
Majority.
I'm sorry, Your Honor, you froze and I didn't hear the first part of what you were saying. Excuse me.
I don't know first part of which, because it's gone on for a while. What is the last thing you have?
Mr. Mason was indicating that majority support the UMPNC, and then whatever you said after he finished speaking. The first part of it, I did not receive.
Okay. Kind of stop me earlier. I will have to try to remember.
Okay.
I had indicated I think I had indicated that in essence, the issue seemed to turn on whether or not majority as represented by MNPC is in fact majority under the relationship between MNPC and NMA or its relationship with the University of Michigan, because while there does not appear to be a question about whether or not a majority of those persons who were registered and voted at that meeting voted to disaffiliate, there is a question as to whether or not that constitutes a majority of the persons represented by the collective bargaining unit. I think that's the essence of what I said. Does that seem fair? Okay. And you were about to respond, Mr. Mason.
Judge, what you just said is correct.
Okay. Now, what document, if any, would you point me to focus on the definition of a majority?
So I would point to Merck Case Law. So Merck Case Law and the case that is cited at page 11 of our initial brief, Wayne County Regional Educational Service Agency, 8 MPR 26003. In that case, that dealt with an employer committing an unfair labor practice when they withdrew recognition from an incumbent union and granted recognition to a union seeking representation. What the commission said is that the employer didn't have evidence that a majority of bargaining unit members supported the incumbent union. So what we need is a majority of the total bargaining units,
Okay, so
6,300, 6,100 people.
Okay. And in that case, there was, I mean, you have to drill down to the details. In the Wayney case, was there evidence allegedly presented that a meeting was held with notice?
No, it was not a disaffiliation. It was not a disaffiliation vote case.
So it's a decert, right?
No, it is a voluntary recognition. It is the employer chose to withdraw recognition, which is what UMPC asked us to do.
Well, okay. My fuzzy understanding of this in my attempt, as your colleague put forth, was that we have many different circumstances where an employer is confronted with a request that they recognize a different entity to represent its employees. That the context of voluntary recognition is very similar, is more similar to the context of decertification, because in that context, the employer is dealing with a different series of unknowns. Is there any case where you have, and I know this doesn't happen that often, where there is a union that is affiliated with a broader group of unions that wants to walk away from that relationship? But are there any cases floating around there that talk about that, and whether or not then the context of a majority is not a raw majority of all human beings within the group, but a majority as defined either by the previous affiliation agreement or some other document?
I'm not aware of any cases.
Your Honor, if I may, I cited
those
cases.
It'll be your turn.
Okay.
In a minute, after your colleague gets to speak. So you would suggest that the cases that your colleague cited were inapplicable, and that there is no difference between voluntary recognition and a disaffiliation circumstance?
In this context, yes, because again, what we have is a situation where the M&A is the sole certified bargaining representative by the Michigan Employment Relations Commission. In the cases cited, in the disaffiliation cases cited, counsel has not presented any disaffiliation cases where we had a situation where the local that walked away was not the Merck certified bargaining representative. In the one case that's unknown, the Wayne County case, it wasn't cited one way or the other. But the only case that deals with this issue and this issue on point that dealt with the issue is the NLRB case, Yates Industries. None of the cases cited by counsel deal with the issue where you have a Merck certified bargaining representative. So they are distinguishable.
Okay, I understand your argument. Is there more you want me to know?
I rely on my brief, Judge, unless you have more questions.
I do not, thank you. On behalf of the M&A.
Good morning, Your Honor. I think I'd like to, if you don't mind, go back to where you started us. which is in the specific injunctive relief that the plaintiff is requesting. Pardon me, I'm getting some static here. Can you hear me all right?
I can. I don't know.
Okay.
Ms. Williams, if you can't hear anybody, tell us something.
Yes, Your
I think-
Honor.
Thank you. Please proceed, sir.
The plaintiffs are asking for three, as you observed, the plaintiffs are asking for three elements of injunctive relief here. First, they're asking that you order U of M to recognize the former officers of UMPNC as the representatives of UMPNC. And the second thing they're asking is that you order the university to stop recognizing the current officers of UMPNC as the representatives of that organization. And I'm going to just go back to, I think one of the things you said earlier is that we should use the abbreviation UMPNC, use the letters. And unfortunately, that's a difficulty too, because there are in fact two UMPNCs, which creates a bit of confusion. There is what we consider the legitimate UMPNC, which is established under the MNA's constitutional bylaws. And then there are former officers of UMPNC who left their positions and who are using the name UMPNC. But putting that aside, as to those two elements of the injunction that they ask for, that all comes down to who controls and represents UMPNC. And that is an internal dispute between and within the MNA, between these organizations. That is what is being litigated in the case in Washtenaw Circuit Court between UMPNC and its individual former officers and the Michigan Nurses Association. And in that case, which is being brought under Michigan contract law, basically under the union's internal governing documents, as to who has a legitimate role in running and representing that entity, Judge Connors has denied an injunction. Your Honor, I believe that this court, with all due respect, doesn't have jurisdiction to decide that issue, because the issue there doesn't involve a U of M as a proper defendant. It's an internal dispute within the union. The third prong of the injunction that they're asking for does involve the University of Michigan. And that is that they ask the court to order the university to stop threatening and disciplining the former officers of UMPNC. And really that to me is separate and independent from whether they in fact represent and are officers of UMPNC. That's really a question about their job conditions as employees. So as to that, Your Honor, I don't think this court need venture farther than to examine whether there is any arguable irreparable harm or injury to these employees. Because that, after all, we are in the context of a request for a preliminary injunction, and that is always the first and most important question. Should the court's equitable jurisdiction be applied when there is an available legal remedy, which here there is? This is a request for an injunction in aid of an unfair labor practice charge. And that unfair labor practice charge against these individuals and this purported UMPNC against the university is going to be decided by Merck, and a hearing has already been scheduled. So there's a legal remedy to decide that question, and with all respect, I don't think the court has to delve into it at this point.
Well, but Mr. Nickloff, in all cases where there's a request for an injunction in aid of an unfair labor practice, there is obviously a remedy before Merck, or we wouldn't be able to aid Merck. So we got to go a little further than that.
Right, and that's where I am, Your Honor. I think the dispositive issue here is whether there is cause for a preliminary injunction, and that rests on whether there is any claim that there is impending irreparable harm.
Okay, so let me just maybe zero in on that a bit. While ordinarily a threat of irreparable harm deals with harm to a known and named individual for whom there is no adequate remedy at law, I think even our colleague from UMPC plaintiff would acknowledge that if any of these individuals were terminated and the termination was wrongful, they would have the right to recover back wages, etc. And be restored their seniority rights and all those other things. So that would arguably be an adequate remedy at law. It could make them as individuals whole. What your colleague has chosen to focus on today, if I understand correctly, was not the harm to the individual putative members of the executive committee of UMPC post disaffiliation, but instead the harm to the members of the collective bargaining unit. I think that's what I heard him speak to. Do you want to address that?
Yes. And it's interesting and a little bit ironic because claiming that the employee free choice, that's really the sort of the principle that the plaintiffs assert they're defending, that there's some kind of irreparable harm to employee free choice really rings hollow, because the answer in terms of determining the employee's choice of bargaining representatives, putting aside my concern that they have made a choice of bargaining representative, it's just that there are different individuals operating that organization and representing that organization. But putting that aside, the employee's choice is determined in the way that the statute prescribes, which is that there is a valid petition filed with Merck. There is a showing of interest required with that has to accompany that petition within 48 hours. And the showing of interest must be of at least 30% of the employees in the bargaining unit, not the members.
And Mr. Nick, that is fascinating, and I care. But my question was for you to focus on your colleague's assertion that there was irreparable harm to the members of the putative bargaining unit, whatever you call it, as opposed to the persons who were named as executive committee members, either by M&A subsequently or by UMPC previously.
I'm sorry, I guess I was being too circuitous about it. The only harm to the possible harm to the members of the bargaining unit is that they're not being represented by an entity that they have chosen. I think that's the only harm I can think of. And if that's the case, then there is a process for determining their choice. And the plaintiff
But the process wouldn't determine whether the harm, if it's there, is irreparable. The process would determine what I actually think is the first thing. Is there a likelihood of success on the merits? I have to get to there before I ever get to harm, because people could be harmed horribly by something that is simply not illegal. So unless I find that there's a substantial likelihood of success on the merits, I never get to that part. But you wanted to go there. So I want you to tell me, why would it not be irreparable harm? And I think you really just tell me why it wouldn't be irreparable harm. And then maybe you wanted to go to likelihood of success on the merits, but call it something else. But go ahead.
Okay. The difficulty, Your Honor, is that how would you measure the harm to the employees? And I suppose I understand what you're saying, because the only way that you could find a harm to the right of employee free choice is if the employees had expressed their choice and that
Actually,
was
no.
not being respected.
And I guess this is what, and I'll come back to your colleague in a minute. I'm trying to figure out if we're still following the same collective bargaining agreement, which determines the rights and privileges and responsibilities of the employees and the employer. And if we are not in a circumstance where the duty for fair representation is not met, I don't see what the harm is. You're going to get the right to arbitration above a certain level. You're going to get representation on violations of the hours, wages, and conditions of employment at other levels. You're going to be paid in accordance with the pay scales set forth in the document, or you're not. And if the persons who are charged with protecting your rights as a collective bargaining entity do not do so, they fail on the duty of fair representation, and there's an entirely another cause of action. So I was having trouble figuring out where the irreparable harm to the employees would be, except I agree that the right of free choice is an intangible. And if we were to find that there was a violation of the right of free choice, we'd have to hone in not on just how or if it was exercised, but what's the nature of that harm? And does that harm fall in the category of, in another sense, deprivation of the right to vote, or some other fairly high level or sacrosanct right?
I hope this helps, Your Honor. I think that the right we're talking about here, because you focused just now on the collective bargaining agreement and performance of obligations thereunder, and I think that makes sense. But the collective bargaining agreement that the employees ratified says that Michigan Nurses Association and its UMPNC, its local unit, are the bargaining representatives. That's a very important component of the agreement. It's not just wages and grievances. It's who is speaking for me and on behalf of me, of these employees with the employer. So the agreement is important, and it identifies who the parties are. Now, there's no dispute about who MNA is. It's the certified bargaining representative. And so by ratifying the agreement, the employees have again said, we want MNA. And there are good reasons for that I don't need to go into. But there also is a party identified as its UMPNC. And so the dispute here is who is UMPNC. But the court doesn't need to resolve that respectfully, because the employees are getting the benefit of their agreement, having U of M and one of the UMPNCs representing them and administering the agreement. So if the harm is that the employees are covered under an agreement that sets forth the terms and conditions of their employment, that hasn't changed. Okay, I don't know if I've answered your question, Your Honor, but you
gave me your answer.
Okay. If I can, I just briefly would like to touch on the merits as well, because I understand your position that the merits are of great importance here too. And again, though, I would say that apart from the fact that Merck is the agency that has been assigned by the Public Employment Relations Act to decide that question, I'm not going to echo what Mr. Masson said, but really there is no basis in Michigan law for questioning the status of MNA as the certified bargaining representative and of UMPNC, which is now being administered by its current officers installed by MNA according to its bylaws as the proper representatives until the situation changes, if it does. And that the theory, I guess, that the plaintiffs have here is that they took a disaffiliation vote and that somehow overrides the certification issued by Merck years ago and the recognition that's required under the Public Employment Relations Act. And they cite cases that talk about mostly about affiliation, not disaffiliation. And I think Mr. Masson is correct. The only, the best case for disaffiliation, which is what we're talking about here, is the Yates case that was decided by the NLRB. But putting that aside, in these cases, there are Merck cases on affiliation. In other words, a union is representing the employees it affiliates with some parent. Does that somehow disturb the status of the union as the exclusive bargaining representative? And in those cases, the courts look at whether there was a free and fair election by the employees supporting that affiliation. And they look at things like notice and the security of voting. And as we said in our brief, there are good reasons to question as a factual matter whether this vote, this disaffiliation vote, was properly conducted. There were no secret ballots. It was conducted in 3 Zoom meetings after a week's notice as employees returned to work from the holidays. And there was some confusing language in the resolution that told employees about this vote. As it is, less than a third of the members of the bargaining unit attended this Zoom meeting. And regardless of what you think a majority is, it's not the 17 or 18% of the bargaining unit members who voted for disaffiliation.
Why isn't it?
Well, because again, para, if you're going to take the disaffiliation as requiring recognition of a change in the bargaining representative, then para requires at least to have an election to determine the employee's choice, that there be a showing of interest by 30% of the employees. And this is about half of that. So para doesn't allow less than a fifth of the employees in a unit to say, we're going to switch bargaining representatives. And the employer has to honor our decision, and the courts have to honor our decision. That's not what the act says. And we're operating under a statute that pretty specifically regulates how you determine employee choice and what the consequences are of that choice, which I don't think we can escape here. The other component is the operation, and whether the operation of the union, as Mr. Fetter said, and whether it's significantly changed. And we can, there can be a dispute about that. But all of this really is beside the point, because the real question here is who is the employer required to recognize as speaking for the employees? And the statute sets out the roadmap for that determination. There's no evidence here that that roadmap has been followed, or that the court would have a basis for interfering with that process, that Merck procedure, based on what you have before you, which is 3 Zoom meetings where employees voted using the chat system on Zoom, where there were no safeguards as to who was voting. There were no secret ballots. And in any event, the result of the vote would not have any dispositive effect on the legal status of these parties.
Well, I guess the one thing I would point to you on Zoom votes is we are now having public bodies vote on Zoom to do major business of the people. So I'm not, and we're having an alleged court of record on Zoom. The fact that the process is a process developed out of a pandemic does not make it suspect. I am, however, concerned that in this unique circumstance, we have to draw the proper attention to analogous procedures. And I'm not sure if it's the para calling for a vote or if it is some other, but I'll be thinking about that for a while, I guess. If you have nothing further, we could finally hear from counsel on behalf of the plaintiff.
Your Honor, if you don't mind though, could I just respond to what you said?
Respond to what I'm thinking about?
Yeah.
Okay.
I'm not saying that it's impossible to have a legitimate employee vote, disaffiliation vote, in today's current conditions. But what happened here was nothing close to that. I'll give you an example. I know public bodies like city councils and boards of trustees vote, but they're voting in a public meeting and they're raising their hands, and you can identify who's
okay.
who,
Counsel, let
what.
me just bring it easier to you.
Yeah.
We've had criminal trials done by Zoom.
Right.
And those are the ultimate in anonymous. I don't want to have I really wasn't trying to go to a philosophical, what do we do? How do we function in Zoom? I'm pointing out that procedure in and of itself is not illegitimate, and the fact that was used is not a significant basis to have an absence of good faith. And since it's not, it is an issue for your case in front of Judge Connor. It is not the issue of good faith is an issue on behalf of the University of Michigan. And whether or not their assertion that they do not have good faith belief that a majority wanted to make this change and had the legal capacity to do so is an issue that's in front of me. And I was sharing that the Zoomness is not going to move me. Okay.
Your Honor, I'm not arguing it. I just would say that unions typically do things with mail ballots, and then you don't have these issues. You have controls, and there's oversight, and that's often used. It's used by the Michigan Nurses Association to elect their officers.
I just got a piece of mail sent by 2-day overnight mail in metropolitan Detroit 3 weeks later.
Well, I'm not saying there aren't problems. I'm just saying that there are better ways, more reliable ways
better and more
that were
reliable
used
is
here.
not what's required. Is it illegal? Okay.
I understand, Your Honor. Thank you.
All right. And finally, sir?
I believe you're referring to me, but I want to make sure which sir.
Pardon me, I forget that there are a whole lot of sirs. Finally, on behalf of the movement, the petitioner, UMNPC.
Yes, Your Honor. Thank you very much. A couple things that I wanted. First, I just want to direct your attention to the affidavit of President Catherine Oppenheim, which laid out the voting procedures. And Mr. Nickelhoff has asserted that it wasn't secret ballot. He has no evidence of that. It was secret ballot. It was the anonymous poll feature. And I don't think it's appropriate just to make a blanket assertion that it wasn't a secret ballot without any evidence. Anyway, setting that aside, I want to direct your attention, Your Honor, to the case law, particularly that's cited in my brief in response to the M&A that ends on page 3 going into page 4, specifically Operating Engineers Local 547, 1989 Merck Labor Opinion 775. In this case, they followed.
So if I'm going to go look for this, this is your reply brief?
Yeah, this is my response to the M&A brief.
Okay, which I would think of it as reply, but okay.
Yes.
Got it. So I know which one, because you guys gave me a lot of paper.
Yes, we did.
Thank you.
In that case, Merck followed board precedent, which said that in these sort of elections, like this disaffiliation election, it is not required to have a majority of those eligible to vote. It is required to have a majority of those voting. And if you think about it, that makes a lot of sense, because Merck, when they have an election, they don't require a majority of those eligible to vote, only a majority of those voting. So and they can cite to no other case, because every case that has ever been argued at the board or at Merck on that issue, because employers have made that issue before, have gone against them. And so the requirement under the law, under the case law, is a majority of those voting, not a majority of those eligible to vote. Moreover, I do want to discuss for a moment the Wayne County case. The Wayne County case is the most on-point case. It is a Merck case where a local union of the MNA, which was the Wayne County Professional Nurses Council, very similar to the University of Michigan Professional Nurses Council, disaffiliated from the MNA. And Merck ordered that since the procedural safeguards were met and since there's substantial continuity, that the employer was correct in recognizing the disaffiliation. Now, in that case, Merck went as far as to say that the employer was right to no longer recognize MNA. But that's not necessary in this court, because as much as Mr. Masson and Mr. Nickelhoff assert that this case is about a change in bargaining representative, it's not. This is about, in the interim, the status quo ante. The status quo ante that existed on January 20th, 2021, was that U of M recognized the elected leaders of UMPNC as the representatives of UMPNC. We're not.
No, I want to ask a question about that. I've seen some certifications and recognitions. I've never seen one that addressed the officers. It usually just addresses, we recognize entities X and Y. Doesn't say elected representatives, doesn't indicate until they change their minds. It merely addresses two entities, or one, usually one, two is kind of unusual, but two entities that are recognized as a collective bargaining unit. And it is apparently based upon the context at that time, that one is an affiliate of the other, if they're two, or that the other has been duly recognized either by voluntary or by an election. Is there something in this recognition or in the the collective CBU that says anything about officers?
Well, the CBA does say things about officers, about release time and things of that nature, but not in the recognition.
It's whoever they are.
But not in the recognition clause. The recognition clause recognizes UMPNC and MNA.
Two corporate entities, okay.
Two entities. Then the issue is, once the MNA illegally took over UMPNC, what was the employer's obligation in the face of its assertion that to get rid of the elected leaders of UMPNC? Well, at that time, there had already been a disaffiliation election. Under Merck law, they were obligated, the university, to recognize the disaffiliation. They refused. By recognizing the disaffiliation, as is their obligation, they would have recognized that, hey, the MNA doesn't have control over UMPNC anymore. And let me finish addressing the Wayne County case, because the only way that they can distinguish the Wayne County Professional Nurse Council case and this case is that Merck made no mention of who originally was the certified bargaining agent. And they say because of that, you can't follow the case. But the other, I think the more reasonable analysis you can take is that Merck didn't find that fact to be relevant. Because just like here, at the time, the recognized bargaining agent was both the MNA and the WCPNC. What had happened 40 years ago, I don't dispute that in 1975, that the MNA was the sole and exclusive bargaining agent. But this isn't 1975. Who is the recognized bargaining agent right now? It is UMPNC and MNA pursuant to the contract. So their attempts to distinguish the almost identical case in Wayne County is very hard to do. Mr. Nickelhoff asserts that there are two UMPNCs. Apparently there is one that elected officers in October that condemned the M&A for their affiliation with another organization, NNU, and voted to disaffiliate. And then there's some other entity. And I don't know what that other entity is. They've presented no evidence that they've created a second UMPNC. I only know of the one that I represent, which has voted to disaffiliate from the M&A. And perhaps they do that because of the Yates case that they rely on. Because in the Yates case, there was, when the local disaffiliated, it created a new local under a different international. And the international that was recognized kept their local. And in Yates, they said, well, the local still exists, and it exists under the international that's recognized here, so you can't represent this other international's local. That's not the situation here. So maybe that's what they're attempting to do, is to create another UMPNC to make an argument, a better argument under Yates. And as to the irreparable harm, Your Honor, I do want to address that a little bit. And as you probably know, and is cited in our brief, that when state law is silent, or state precedent is silent as to labor law issues, state courts get their guidance from the federal courts. On irreparable harm, there is no case on point that's like this under state law on irreparable harm. I'll give that. But there is under federal law. Under federal law, and I'm going to point you to the direction of where this is discussed in my brief. Excuse me if I can get to it. Under the Ganghale case, which is cited on page 10 of my reply brief, as you called it, the response to the M&A brief, the court found in an almost identical situation that the loss of self-determination, where the local's members have a right to select their representatives, direct their local, and the deprivation of that right is a substantial right that cannot be meaningfully recompensed because it constitutes irreparable injury. It is a significant right, and it is a right that is in statute, that the members of UMPNC have the right of free choice, which is a basic underpinning of all labor law, to select their representatives, and including select their leaders. That is part of their self-determination. And what's been done is they've selected their leaders through an election. And that has been thrown out by the M&A and by U of M. And it's been thrown out illegally, but we're challenging that. So the issue here is just as to irreparable harm, there is nothing that an election does to remedy anything. They cite that an adequate remedy is an election. An election doesn't even have remedies. It's not even a case. So, I'm sorry, you're about to speak, Your Honor. I didn't want to interrupt.
No, it's okay.
So
you were speaking and I didn't want to interrupt you, so please.
every day as we move ahead, the members of UMPNC have lost their self-determination. They have lost their right to be represented by representatives of their choice. Instead, they've been replaced by inexperienced representatives appointed by the M&A, many of whom lost their elections. So when they had officers' elections and the nurses said, these are the people that we trust, that we vote to represent us. They're experienced, we respect their views, they've done a good job for us. And then somebody else lost the election. Well, the M&A put in the people who lost. That is not the representatives that the nurses want nor deserve. And every day they are being represented right now by those individuals who are inexperienced and do not have the support of the membership. Thank you, Your Honor.
Okay, I have a practical question to ask. The persons who are elected as executive committee members of UMPC plaintiff, what is their current status? in terms of have they been reassigned to nursing duties?
They've been reassigned to nursing duties.
Are they performing, did they take those reassignments or what happened?
So many of them, Your Honor, just to back up for a minute so that we're all on the right premise. Some of them worked full-time as nurses already, and then would get leave when they were needed for their particular function that they served. So if they had to go to a meeting or something like that, they would leave their full-time job. There are 3 of the executive committee members who are on full-time release to perform union duties full-time. And that was the president, vice president, and dispute chair, the person that handles the grievances. Everybody, so the 3 that were on full-time release have been assigned, and I think they started working within the last week or 2 as nurses back in the unit.
Okay. And there was a discussion about their use of university equipment to communicate. Did I remember that correctly?
Yes. So
Okay.
customary, oh, I'm sorry, go ahead.
And my question is, I'm not going to get this decided for a week because I'm not. And my question is whether or not the university would agree, not being ordered to, but agree that those 3 individuals or that class of individuals can at the least have the opportunity within the confines of their work duties. So that, I mean, clearly patient care is first, but would have the ability to utilize university equipment for the purposes of communication relative to their putative status as collective bargaining agent executive committee members pending the resolution of this motion.
The concern that causes, Judge, is then we have competing union members, so competing presidents communicating with.
You do already, and you're going to have those competing presidents, whether they're competing on their computer at home or whether they're competing on the university's computer. I was just asking if you would agree to forego any discipline action for the 7 days I need to write this. And if you can't, then I'll decide whether I have to do something in the interim.
Judge, I'm not willing to forego disciplinary action voluntarily.
Okay. Then you should anticipate something that's going to tell you have to do it involuntarily. I just thought it might be a simpler way to go. Okay. I will give you a resolution of this within 7 days, and then you'll be on your way to the Michigan Court of Appeals.
All right. Thank you, Your Honor.
Thank you, Judge.
Thank you.
Thank
Judge.
you. We are in recess.
Oh, one moment, please. Is there any way I can have a copy of one of the briefs just for spelling purposes sent to me? Is that
I
allowed?
assume that had happened. The court will take care of that.
Thank you, Your Honor.
Okay. Thank you.
Thank
And
you.
before
Thank you,
I
Ron.
leave, I'm told
Yes,
to
ma'am.
ask for, I'm not sure if the court automatically orders a transcript or if each attorney orders it, but I am instructed to ask.
That's interesting. They should instruct you to ask that probably before they start. But the court representative will contact you. We will order a transcript. The individual counsel all have the opportunity to order a transcript as well. I'm sure they're going to. And I was presuming that they were given the information as to how to reach you and your service prior to this hearing. I'm now seeing people shake their heads, and I now know that we don't do that. So we're going to have to fix that little glitch. You will get a contact, Ms. Williams, immediately after this phone call, after this Zoom conference from Morgan, who will give you our information. Similarly, she will get all of your data and will make it available by virtue of an email communication to all counsel for parties represented. Does that take care of that?
Yes, Your Honor.
Okay. Does anyone else have any challenges that are a surprise to me? Well, they may not be a surprise, but anything else that needs to be managed administratively?
No, Your Honor.
No,
Okay. Thank you for your excellent briefing and arguments.
Thank you.
thank you, Your Honor.